Hello, everyone. Thank you for being here with us today on behalf of the International Human Rights Clinic and the Center for International and Comparative Law. Welcome to this event on artificial intelligence and human rights. Our event today is also co-sponsored by the Duke Human Rights Center at the Franklin Humanities Institute, the Human Rights Law Society, International Law Society, and the Duke Law and Technology Society. This is a fascinating and really varied topic, and we have fascinating and varied perspectives represented by our panelists, so it's very exciting. I'll briefly introduce our speakers, then invite each one of them to give approximately a 10-minute presentation before opening up to the floor for your questions. So we're honored to have with us today, in the order in which they'll be speaking, Rebecca Mignon-Mondavi, Assistant Professor of Law at Sciences Po Law School, Asaf Lubin, Associate Professor of Law at Indiana University Moore School of Law and Visiting Professor of Law at Columbia Law School, Jared Klein, Head of Advocacy for the International Disabilities Alliance, and Duke's own Professor Nida Farahani, Robinson O. Everett, Distinguished Professor of Law and Philosophy. Without further ado, I will turn it over to Professor Mignon-Mondavi to begin.
Thank you so much, Monica, for your kind introduction. Can you see my slides?
Yes, we can.
Great. Okay. I now see you in a very tiny spot on my screen. Thank you so much for the invitation. I'm really honored to be part of this event and alongside such distinguished co-panelists. I'm looking forward to having a discussion on AI and human rights law, and my work mainly focuses on security practices using new technologies. So I wanted to share a few thoughts on how I look at AI security and the law as what I call a techno-legal machinery, in the sense that I picture these different actors as part of a network, as co-constitutive. And in that case, I want to start with a provocation also, this discussion by sharing some thoughts on how I think that this techno-legal machinery is an art for not changing the world. And the provocation here is that, of course, the mainstream narrative and discourse is that techno-legal modes of governance, algorithmic modes of governance bring change, that they revolutionize our world. And the point that I want to make, and I'm sure that there will be ramifications with what some of my co-panelists will say as well, the point that I want to start with, and I will also end with it and guide you through some thought process and different case studies very briefly, that show that AI, security, and the law tend to fix and stabilize some features of our world, some problematic features of our world. And this is mainly because security practices that use AI systems build on historical past data to predict, anticipate the future. And they promise to do so with objectivity, truth, scientificity. And by using past data to predict dangerousness in the security realm in particular, I argue that these modes of governance code, fix, often very racialized, gendered representations of normality, abnormality, and dangerousness. So very quickly, two short case studies. The first one concerns algorithmic border control. What you see on this picture that I took at the World Border Security Congress in June 2022 is a representation or a presentation slide, in fact, of a US representative of their so-called ATS, Automated targeting system global. So as many of you probably know already, ATS is a US Department of Homeland Security computerized system. And for every person who crosses US borders, ATS scrutinizes a very large volume of data related to that person. And that then automatically assigns a security rating and sometimes puts the person in a risk group. And on the slide you see, and of course the US is not an exception in deploying and developing this kind of systems. And on the slide, you see the very reductive and essentializing criteria under which someone is detected by the machine and considered as a potentially dangerous individual. So males, ages 16 to 50, who have stayed in, this was an example given by the speaker, in Pakistan for more than 75 days. And this would trigger a high risk score. Of course, we could speak, and a lot of literature focuses on biometrics that is used at the border and the digitalization of borders, but we can keep a discussion, this as a discussion point for later, just because I'm the first speaker and I'm aware that in the room not everyone is familiar with the technology. Biometrics is very largely understood to be a system of systems, technologies for measuring, analyzing, processing a person's physiological characteristics. And this goes through fingerprints, iris, facial patterns, voice, hand geometry, DNA, etc., etc. And the contemporary biometrics use digital technology, but of course, it's not a recent phenomenon that states desire to read identity from human bodies and understand individuals from their bodies and behaviors. The second short case study that I want to share with you is one that relates to algorithmic predictive justice. And here, when I follow the algorithmic trajectory of the individual spotted as dangerous, it often starts with watch listing systems prior to any judicial proceedings, prior to the commission of violent acts. Remember that this is really core, this anticipation objective is really core to the security practices that I'm talking about. And I've been studying case law from several EU member states, showing that judges start to pronounce sentences against individuals based, for instance, on intercepted digital communications at this stage of watch listing. And then the algorithmic trajectory continues in some places in detention. In others, it's not necessarily automatized, so it's still human-led. But I want to show you also a snapshot of how in a criminal justice system that believes in the power of algorithmic systems and AI systems in general, how it shapes also the human detection of dangerousness, the human-led exercise of evaluation in detention. But before getting into this, just to finish on this algorithmic trajectory, we see that it continues after detention with post-detention surveillance and the reactivation of watch listing systems. This won't tell you much because it's all in French, but it's a picture of a document used by the French Ministry of Justice and prison authorities to evaluate the level of risk posed by individuals in detention. So what you see on the column on the left, it indicates suspicious criteria in the behavior, appearance, and life pattern of individuals in detention. And the other column defines and gives examples of these indicators. And so from the criteria, for instance, you see follows a specific diet without pork, possesses a prayer mat, wears a djellaba, as a sign of religious confession that could be considered as suspicious. You can see how this search for dangerous individuals, allegedly dangerous individuals, is often reductive, quite racialized, and of course, especially affects certain religious communities. And what is very interesting to me, because often when we are focused on new technologies, we forget to talk about the human-led operations in an algorithmic universe, in a digital universe. It's quite interesting to see how the belief in the algorithmic detection of dangerousness also somehow influences human-led surveillance activities. So it kind of roboticizes a little bit the way in which individuals conduct evaluations. And I can say a little bit more about how it's done. So the point that I would like to discuss with you is how AI-enabled surveillance and security technologies rest on a belief in the knowability of the body, a belief in the capacity to capture through body mining what is invisible to human beings and make it legally actionable. And of course, it fixes, as these examples show, identity in a very, in that case, racialized and gendered ways. So what is the role of human rights law in this equation, in this techno-legal that I'm talking about, the techno-legal machinery? What I find quite interesting is that, so what I try to show with these two short examples is that the digital world kind of emphasizes our modern belief in the light of reason, in the scientifically and automatically discoverable truth. And in my view, in the same vein, privacy and human rights law's dominant doctrines somehow cultivates a tight link between perceptibility, data about us that algorithmic systems can capture, and privacy, what needs to be protected. So it somehow perpetuates, it cultivates the modern belief in the idea that what is capturable, perceptible about us is what is the most intimate, what deserves to be protected. Right? If we agree, if we only focus our human rights discourses on the necessity to protect what can be perceived, it somehow perpetuates the belief that the same data has to be captured, sometimes for security purposes, sometimes for marketing practices. So the fact that human rights and privacy rules and doctrines further saturate our world and practices with the belief in a digital recording of reality, or at least in my view, do not serve to challenge the belief in the algorithmic capture of so-called reality is something that is, in my view, underexplored. And what is missing from these frameworks so far, and maybe it's an invitation also to think of ways to reinterpret our doctrines or reshape our doctrines, is or could revolve around a questioning of what is uncapturable is left unprotected. So it's an invitation that I end with to start thinking about a human rights discourse and narrative that would cultivate and protect people's thickness, fluidity, density, that would try and protect our unreadability, the idea that we are individuals, communities, unreadable, unknown. And here, of course, I think of Édouard Glissant, who is a French philosopher and poet from Martinique, who has, although he's not an international lawyer, nor a lawyer at all, he has talked about the right to opacity, and thinking of opacity not as a right to be opaque, but as a right to be understood as not knowable. And I want to leave it here. I hope I didn't speak for too long, and I'm very much looking forward to the conversation. Thank you.
Thank you. That was great timing and a fascinating opening for us that I think our panelists are going to have a lot to engage with as well. So I'll turn it over to Professor Lubin.
If you can put those slides on, that would be great. And if I can get a click or something to run that.
It's the launch slide.
So It's a pleasure to be here in person, my first time in Duke. And what you heard, Rebecca is one of the topmost scholars in this area, and it's a real privilege to just go flowing straight from her talk. What Rebecca did a great job of is discussing AI in context of national security environments, particularly law enforcement activity. I want to just shift us slightly into military environments too. And I would argue to you that a lot of the things that Rebecca identified for us as problematic are just going to be exacerbated in the military context. The traditional analysis of AI in armed conflict scenarios is focused almost predominantly around lethal autonomous weapons systems. And I actually don't want to focus my presentation today about laws. Not because laws are not pervasive in its usage, not because they're not introducing the same kind of lock-in effects and dangers around algorithmic bias of the kind that Rebecca identified, but just because I think it tells you a very misconstrued picture of the degree by which AI is currently utilized by militaries around the world. The reality is that AI is everywhere. It's ultra pervasive in the activity of a large swath of militaries. It captures an array of environments, not least of which is the intelligence, surveillance, and reconnaissance space, but also AI is being utilized to manage logistics support, command and control structures. AI will support decision-making of military commanders across the entire supply chain of the informational environment around which militaries are operating. Really, militaries are becoming mass aggregators of data and are relying on that data to engage in various predictive analysis for all kinds of operational purposes. So much like Rebecca did, I want to start with a few case studies just to whet the appetite. Rebecca mentioned the use of ATS in the border in the U.S. I'll use an equivalent example in occupied territories, so that is Israel-Palestine. Israel has been relying on artificial intelligence, biometric collection, and facial recognition across the West Bank. And in so doing, one of the most controversial programs compelled every Palestinian who was entering Israel for work purposes to download an app called The Administrator, which they didn't tell the Palestinian employees that that the app will collect all the data from their phones. This went all the way to the Israeli Supreme Court. At first, the military challenged the factual claims. Ultimately, it admitted to it and ended the program. But it's just demonstrative of the kind of collection activity that could be done in military environments, including occupied territories, and the degree by which militaries can rely on intelligence and information gathering in ways that are way more pervasive than once before. Another area of data collection and analysis in coalition operations. So to advance the missions of the coalition, militaries share data with one another and create shared databases. And the challenge there is that there is a question about which law governs these kinds of databases, particularly as we move towards data environments where different data regulations apply. And so think about the most mundane form. If the US and Germany want to collaborate in a military activity and they want to share the health data of the soldiers within the activity, say someone has asthma, how do they do that in a data protective compliant way? Whose law is applicable, the GDPR of the Europeans or an American non-GDPR HIPAA environment? These are hard questions to answer, and there's long debates within NATO on how to think about these kinds of questions. A third example has to do with post-military activities, so collection of open source intelligence to advance criminal investigations. The prosecutor of the ICC has recently announced that he will engage in extensive cyber forensic analysis, in part to advance cyber criminal investigations, in particular crimes involving cyber activity. But we also know that victims on the ground are being called to turn out their phones and collect evidence using their own devices. As well as to rely on commercial satellites, as we saw, for example, in the investigation of the kidnapping of children from Ukraine into Russia, which the ICC is now investigating, some of which was conducted on the basis of open source satellite imagery. And so on that too, there are complex questions around how do we protect privacy and data protection in environments where there's more and more reliance on information gathering. I will tell you here, one of my most interesting areas of discussion, of study is the fact that most of these international courts and tribunals do not have outward-facing privacy policies or cybersecurity standards, which I think is really problematic in these areas. International organizations are too becoming mass collectors of data. The ICRC is at the forefront of this. They engage in cash provisioning, so in order to provide cash to refugees and asylum seekers, they rely on apps and technological solutions. They amass data, including through the use of biometric imagery in certain scenarios, in particular around refugee sites. The ICRC has also been the subject of a data breach, a hack, allegedly by a foreign government. So when you think about the potential abuse of this kind of data on the most vulnerable in our society, and the extent to which foreign governments who might have value in collecting that data, what they might do now that they know that these organizations are the primary collectors of this information. The ICRC is also in the forefront of creating a code of conduct for the regulation of its data protection practices, yet the ICRC is notorious for saying, I'm an international organization, therefore I'm entitled to immunity as an international organization. Thus, I'm not bound by any one country's data protection regulation. I'm above it. And so to the extent that the ICRC regulates its own data protection practices, it does so voluntarily and internally through grievance mechanisms that it itself controls. And I think that is too highly problematic. Now, the reality is that we've had actual harms manifest. So one example of this could be from the US's own botched departure from Afghanistan, in which it left behind retina scans of a number of informants who assisted, Afghan informants who assisted it throughout its days in Afghanistan, retina scans and machinery that was then picked up by the Taliban, who went after those informants for their support with the US. In fact, the U.S. was not alone. The U.S. and Canada's Foreign Office had images of these individuals on its website that it failed to cleanse prior to the departure. It was those images alone that had revealed the identities of some of these individuals against whom the Taliban went, again, asking hard questions around data protection and privacy protection in these environments. So against this backdrop, my colleague Russell Buchan from the University of Reading and I co-edited a volume called The Rights of Privacy and Data Protection in Times of Armed Conflict. It was released last year with NATO's Center for Cybersecurity, the CCDCOE. The QR code is my attempt to get you to see it. It's free of charge, completely accessible online. But one of the things that all of the authors in the book try to identify is the extent to which we can find regulation within lex lata, existing laws of international law, to regulate these behaviors. And the reality is that there's a lot of limitations on existing law, beginning with the Geneva Conventions and the treatises of IHL. These conventions have never mentioned that word, privacy, let alone data protection. They were drafted in times before the advent of the internet, 1949, 1977, for the additional protocols. And while privacy was certainly there, that is not a focus that the Geneva Conventions took. So there is references from which one can draw analogies, such as references to humanity or dignity. In particular context, say POW protections, there is references to special surveillance and rules regulating that, or the use of balloons in natural territory. You might find particular provisions, but your ability to extend through analogy the whole scope of the conventions to cover this wider range of potential harms is extremely limiting. Now, it is in that context that perhaps human rights law could play an increased role to help regulate these environments. I'll skip this slide. And the reality is that human rights law for the last 20 years has been at the forefront of regulating varied uses of emerging tech, particularly around surveillance activity and data gathering. So the European Court of Human Rights, the Human Rights Committee have been developing a set of principles, standards to regulate particular technologies. What you have behind me is a set of principles set out over 24 cases of the European Court of Human Rights just in the last 20 years, leading of which is Big Brother Watch v UK and Centrum for Advisa v Sweden, where they lay out principles of legality, necessity, proportionality. Now, I'll remind you of what Rebecca said about the extent to which necessity and proportionality and so on are entrenching rather than solving some of these problems. But interestingly, even if we wanted to say that this human rights framework was sufficient in and of itself to address the harms that I identified, the reality is that its usage in these environments is extremely limiting. I'll skip this slide. This is just the equivalent for data protection. Unlike the right to privacy, which was the previous right, the right to data protection is not protected in the ICCPR. It's even less treaty-based, subject to potential customary regulation. But of course, because there's different data protection regimes across the world, there's been challenging just to arguing that it has achieved a customary status. But these are the principles that regulate data protection that the ILC identified going back to the 1990s. But if you wanted to apply these human rights frameworks in an armed conflict scenario, you'll come short because of all the challenges of applying human rights frameworks in armed conflict. The biggest of which is the principle of displacement led by countries like the United States and Israel. But there's others who have said that in times of armed conflict, human rights law simply does not apply. Only the lex specialis of IHL apply. It displaces human rights law. Now, we know that the ICJ and the Nuclear Weapons Advisory opinion has suggested a concurrent application of the two, but the question of the nature of that concurrent application, when can we draw from the lex generalis of human rights law, is highly debated to this day in the literature. Similarly, we have questions around the extraterritorial application of human rights law, predominantly where most of these activities occur outside the territory of the arming states. And then there's a question of the nature of the rights in question. A lot of these rights will be applied against countries who might not be parties to the relevant treaties. And even if they are parties to the relevant treaties, the scope and nature of that application might be limited because of national security reasons, or derogated from in times of public emergency, which war might be considered as falling as. Combined, it creates a very uneasy environment through which to apply human rights law. And so I'll end my presentation by just giving you three very brief one-line suggestions on where we can move forward with this kind of scholarship and thinking. That's the first one. And so the first one would be to push back against national security mission creep. In data protection regulation right now, including the one leading the march, the European data protection regulation, there's exclusions for national security. It just doesn't apply in national security environments, especially as governments work to contract out their national security activities in the area of AI by collaborating with corporations. There's more and more justifications to revisit that idea and to suggest that the data protection regime should apply even in certain national security contexts. The second thing I would suggest is that we need to start talking about corporate governance solutions for these issues. And so in the back there is the 2018 protest that Google had when Google announced that it's going to collaborate with DARPA in the creation of an AI machinery for the NSA. Google employees just said, no, we're not willing to work on that. Ultimately, they pulled out of that contract, but then once the leader of the worker movement within the Google left the company, they signed a new contract in 2020. And so when we think about corporate governance solutions, how do we increase employee and social, cultural, environmental interests within the boards of companies? That's a broader set of scholarship that could have now implications even in the AI and national security environments. And the last thing I'll say, and I think really the most important, is that we need to start talking about formal and informal rulemaking on digital rights protections in times of armed conflict. And what I have been doing for multiple years now is particularly focusing on identifying one government who will put in digital rights protection into its military manual as a model for other governments to follow. It's a very slow cooking process. But another thing that could happen is an ICRC interpretive guidance on the way digital rights could be protected in times of armed conflict. And a third is this kind of academic endeavors that we've been doing. I'll just end by saying that this is a research agenda that will outgrow me and will likely outgrow all of you, but it's one that IHL and human rights scholars have not invested yet enough time in, and I would really put to you to do more work on. Thank you.
Thank you. Appreciate action items for the audience as well. It's great. Jared, we will turn it over to you next. Thank you.
Thank you so much, Monica. Sorry, just to apologize in advance, my connection isn't great. If it cuts out, let me know and I'll film my camera. So I'm here to talk briefly about the intersection of artificial intelligence and the rights of persons with disabilities. Recognizing that, as with any technological advancements, we must ensure that the promise of progress doesn't inadvertently leave marginalized groups behind. I should also apologize, I don't have any slides, so you can have my face very large. And the same dynamics that apply to persons with disabilities, I should recognize, also apply to other marginalized groups, since artificial intelligence tends to reflect existing biases and creates new barriers. The foundation, of course, of human rights standards related to persons with disabilities is the Convention on the Rights of Persons with Disabilities. I'll use the acronym CRPD. As you may know, the US has not ratified that convention. There are 186 state parties. The US signed, but in 2012, the US Senate narrowly voted to not do so. It was 61 to 38 votes, so just shy of 2/3. One could consider that the principles, at least, are customary international law, and I should also recognize the immense contribution that the Americans with Disability Act in 1990 made and continues to make to international disability rights jurisprudence. The core idea of the CRPD is that persons with disabilities have the right to be included in the community and participate in society on an equal basis with others. States must respect, protect, and fulfill that right. Crucially, it frames disability as a social construct through the so-called social model of disability, which suggests that disability is not created from the underlying impairment in an individual. It is the barriers that result from the societal response to those impairments. So in essence, we must ask ourselves how societies respond to human difference, and the answer should be in dismantling any barriers they face through government adopting an inclusive equality approach. One final general background note, I refer to persons with disabilities as if they are a homogenous group. Of course, we know that that is far from the case, not only in impairment type, but also a wide range of other identities, racial, ethnic, linguistic, gender, migratory, and others, which will always impact on the degrees of discrimination and marginalization that they face. One of the innovations of the CRPD is Article 8 on awareness raising, where states parties undertake to adopt immediate, effective, and appropriate measures to raise awareness through society regarding persons with disabilities. There are a wide range of subclauses in the article, but it's interesting in that it is an active obligation for states to try and shape the ideas about persons with disabilities. And one could apply that to AI as well. So I guess by extension, because even if AI is not humans as such, they will then in turn impact on the ideas about persons with disabilities. And I know ChatGPT is just one example of AI, but I was following its early development and applying what one might call the Peter Singer test. This evening, I typed into ChatGPT arguments on why disabilities should be eliminated from society. I didn't put persons with disabilities because that would obviously be a no, but I wanted to see what the position was from ChatGPT on this. And straight away comes back with the goal should not be to eliminate people with disabilities from society. That would be unethical, contrary to principles of inclusivity and diversity. And then it changes the question into the focus on eliminating barriers and challenges that people with disabilities face in society. So in that sense, we can actually already say that ChatGPT is more emotionally and morally intelligent than Peter Singer, who's a somewhat famous Australian academic and so-called ethicist. So I think it's worth noting that at least on the face of it, ChatGPT isn't promoting heavily ableist ideas. I'll briefly run through some of the risks that we see regarding AI and persons with disabilities. Of course, acknowledging that there are many potential benefits as well. My organization, as an advocacy organization, tends to focus on the risks, but we're also grateful to enjoy the benefit of scientific progress through AI while guarding against any harms. So one challenge faced is that AI is acting sometimes as a gatekeeper for social protection benefits, and that biased data sets and discriminatory algorithms can lead to denial of services and support, which may exacerbate poverty in persons with disabilities. There's positive impact in independent living, but knowing also that sometimes faulty AI risk assessments based on certain disability types can result in denied access to health insurance and increased costs in employment, resume screening, inaccessible chatbots and other tools create barriers for persons with disabilities and might exclude otherwise suitable candidates. My next point is about participation. This is a general principle in the convention and specific articles that states should consult with active representatives of persons with disabilities in the development of all decision making, right? So this applies to regulation, policies, practices, and one can transpose this also onto business enterprises. From all of this, we've drawn a few initial conclusions. The first, of course, is that the unprecedented power of AI is an opportunity for good, especially for persons with disabilities, but that technologies should be in line with CRPD standards to ensure that crucial for states, businesses, human rights institutions, and organizations representing persons with disabilities to collaborate on addressing any potential flaws in AI that might arise from biased data sets, lack of transparency, and a failure to accommodate diverse needs. I know that the Special Rapporteur on the Rights of Persons with Disabilities and the Human Rights Council published a really important report in the 49th session of the Human Rights Council in March 2022, which provides a very useful roadmap to ensure that the international community can maximize the benefits of AI while safeguarding the rights of persons with disabilities. This applies also to businesses in the private sector, as I've said. And our view is that legal practitioners or advocates can champion the recommendations in that report to advocate for comprehensive and inclusive human rights due diligence legislation, supporting disability-inclusive public procurement standards, as well as the active participation in the development of AI policies that respect the rights of persons with disabilities. So in conclusion, we're aware that there's a fairly challenging and intricate landscape of artificial intelligence and disability rights, which requires vigilance. Embracing the potential of AI requires a commitment to transparency, fairness, and the active inclusion of persons with disabilities in the development process. And together we can ensure that the promises of AI are harnessed for the benefit of all. The CRPD principles of autonomy, independence, decision-making, consultation, participation, privacy, data protection, and access to active support can all be supported by AI, but we must guard against discrimination, which can be embedded into the algorithms and models from the start. And so that's what we're particularly focused on for the next few years. Thank you.
Thank you very much for that. Do you want to try any?
No, I'm just going to jump in. So,
All right.
One of the benefits of going last is that I get the opportunity to hear from my phenomenal co-panelists. One of the detriments is it means that I am up against time that you all would have to discuss with all of us. So I've decided to forego my slides, and I'm going to try to do just a quick 6 minutes on what it is that I am focusing my work on so that we can turn to Q&A, because I'm really interested in getting all of you engaged in the conversation. So I've been spending most of my time recently focused on the intersection of AI and neurotechnology, in particular, the coming age of widespread neural interface. Most companies, from Meta to Apple, are moving quickly toward embedding brain sensors into everyday devices. These are earbuds, watches, and other devices which, powered by AI, enable exactly what our first speaker was talking about, which is the decoding of the unseen. The rapid advances in generative AI have been startling, and how quickly we've gone from neurotechnology, and here I'm talking about basic consumer neurotechnology, a sensor that's in a headband that can pick up basic electrical activity in your brain, translating that into what we're thinking and feeling. The concept for most of these companies is first and foremost to use it as a switching device. Instead of using a joystick or a keyboard or a mouse, the idea would be to enable much more seamless interaction with all of the rest of our technology. But as the CTO at Meta talked about at MetaConnect just a few weeks ago, together with the chief science officer, this is a story about coevolution with AI. The products that will come onto the marketplace will be general purpose models. Those models will then learn from our data, use our brains and the uniqueness of the way that we think, the way we swipe, the way we type, to be able to decode far more and to co-evolve with us. When every time you type on your virtual keyboard, you push what would seem to be the P, but you really mean O, it learns you really mean O, and it starts to decode your thinking in a way that actually works with you. This can be exciting in a lot of ways. It can be transformational and enable us to have much more seamless interactions with our technology. It can do things like enable people who have lost their ability to communicate, to be able to communicate without the risks of implanted brain technology. Recently, a patient with ALS who had suffered complete locked-in syndrome, using implanted neurotechnology, was able to communicate at a rate of 62 words per minute, which is faster than any prior record for any kind of BCI. And just by comparison, Stephen Hawking at the end of his life could communicate at 15 words per minute. Recently, an individual who had lost their ability to walk had a reconnection between their brain activity and their spinal cord and is learning to walk again. People with epileptic seizures who are treatment resistant have the possibility of minutes to up to an hour before they suffer from an epileptic seizure to get an alert, a real-time alert that tells them they're about to suffer an epileptic seizure, which can be life-saving. For the rest of us, the capability of navigating through the metaverse, navigating in immersive technologies, or just seamlessly interacting with other technology can be profound. Our brain health is getting worse, while our physical health overall is improving. More than 1 billion people worldwide suffer from mental health and drug use disorders. With everyday use of brain sensors, the insights that we can gain about everything from depression to stress levels to the number of times that notifications have captured your attention during the last 45 minutes and what that does to your brain and context switching could really be transformational. So too are the downside risks. There was the image of Orwell was not an instruction guide. It's like the ultimate instruction guide when it comes to brain data. The very same companies who've been commodifying our data for years are the ones who are coming forward with these products. They do not have a great track record of privacy. I've been arguing that we need to move quickly before we reach a place of widespread neural interface to recognize a right to cognitive liberty, a right to self-determination over our brains and mental experiences. This extends much farther than just neurotechnology. If you look at the ways at which generative AI and other AI technologies, from social media to the ways that recommender systems are used, they are designed to diminish our brain activity. They're designed to keep us on devices. They're designed to keep us distracted and unhealthy. All of this undermines our basic self-determination. The way I envision cognitive liberty is by updating our existing human rights to self-determination as a collective right, to also be an individual right, privacy to explicitly include the right to mental privacy, and freedom of thought, which has been interpreted and applied largely to religion and belief, to also safeguard us against interception, manipulation, and punishment for our thoughts. There's important work underway that has been happening from UNESCO to the UN, who are looking both from an AI perspective at broad governance that would address these issues, but also more specifically at neurotechnologies and how they impact us. These conversations are ongoing. It's exciting to see them gaining traction worldwide. And I think people are starting to recognize there's an interconnectedness between a lot of the issues that we're facing and how they're bombarding our brains and mental experiences and robbing us of our ability to think freely. All right, that's a little bit less than 6 minutes. I think that gives us time for conversation. All right?
That was really impressive, and I'm going to very quickly give Jared the opportunity to say out loud what he just posted in the chat, which I think was an addition to your list of potential sources of law there.
Thanks so much. I mean, just to say that, so neurotechnology is also an issue in the Human Rights Council because there's a report about to be released on it, and it's a very interesting area. I mean, from IDA's perspective, it's profoundly concerning in part because it will, there are risks that it can lead to effectively the imposition of normality, which are deeply ableist ideas, including in relation to so-called mental health. I mean, it's not necessarily new in the sense of the lobotomy was once heralded as a great medical technology and was given the Nobel, the people responsible for it, given the Nobel Prize, but now we regard it as abhorrent, and I see many parallels there. And just to say that, the CRPD has protecting a right to mental integrity as part of it. I think it's an underexplored area of international human rights jurisprudence, and I'm really interested in what you said and would love to have more conversations about that.
All right, let's open up for questions, and I'll invite you to also introduce yourself if you're asking a question.
Now I've ceded most of my time to all of you. That means that puts pressure on you to stand up and now engage in the conversation. So ask your questions and please engage.
Yeah.
So I'm actually an undergrad doing engineering, so I love all this.
Welcome.
Rebecca, you talked about this right to opacity, about having, do we even want our tech to know the truth about people, to really go after all those potentially private data pieces? And I wonder how you think about that in relation to how we've tended to see constitutional rights to privacy evolve over time, where as new tech comes out, we sort of whittle down those rights to privacy because, helicopters exist, and then planes exist, and fancy cameras exist. And I feel like over time, our constitutional laws have made it so that, in the short term, we're not okay with it, that this is an infringement of privacy, but then we wait 50, 60 years and suddenly that's normalized. So I wonder how you think about that in comparing to the pressure that all tech companies want to use this data because there's huge motive for them to build products using that.
Thanks a lot. Monica, do you want to collect questions first?
Let's go ahead and take them one by one for now, and if we start running short on time, we'll start collecting.
Perfect. Thank you so much. I missed your first name, so I cannot address you directly. But thanks for the great question that I think I heard almost fully, or at least I understood the main gist of it. I think your question also implicitly includes a point that you're making, and I think it echoes with the point that I wanted to formulate, which is that it's not a rejection of the privacy doctrine, be it in constitutional domestic law or international law, and human rights law doctrines altogether. So the idea is not to reject them altogether, but to say that there is only so much things that they can do in relation to new technologies that rest on a belief, or the security practices in that case, using new technologies, and that cultivate the belief that individuals can be known and that the truth about their normality or abnormality can be detected. So it's not to say that the data that is protected using this framework is not intimate. I do believe that there is some level of intimacy that requires to protect this data about us. But it misses a whole part of our universes as individuals and communities. So it's more the gray zone that it leaves unnoticed that interests me here. So it's not a full rejection. It's just to say there is probably a room in human rights law as well, and in constitutional law probably, to talk about the unknowability of individuals, the unreadability. So I hope I answered your question, or at least reacted to your own reaction.
Can I offer another reaction to it? So one of the challenges I see with U.S. constitutional law specifically in this space has to do with the ways by which new surveillance technologies are being deployed by law enforcement, and we only engage in constitutional analysis ex post factum. So a lot of the cases that you've laid out, from the use of planes to the use of infrared to all of them, police, to the use of hacking nowadays, all of them, police officers first utilize them, then it gets challenged in a court, finally gets to the U.S. Supreme Court, and then maybe we're told that this is a search and seizure subject to the Fourth Amendment. But it's all the opposite of the way human rights law would do it. Because in human rights law, the first principle is called the principle of legality. And the first act you'll need to do is to authorize the agency to use the technology in question and to set limitations that are foreseeable and accessible on the way this is statutorily designed. And I just as a one tiny example, highlights to you where I think there are real core fundamental issues that we need to regulate and that human rights law could offer some solutions.
Yeah. And Tatiana.
Hi, I'm Tatiana. International Comparative Law. I wanted to follow up on your comment on the lack of outward-facing privacy policies at the ICC and other courts. I guess that combined with, not having a great track record handling digital evidence, how can we ensure that courts both abroad and in the U.S. are prepared to understand open source information and other forms of digital intelligence and balance rights to privacy with rights to justice and restitution for victims?
So it's a combination of challenges that both domestic and international courts are facing in the move towards digital evidence. One set of challenges has to do with literacy. So do our judges get trained enough in understanding the very technologies that are being employed by investigators and are then being turned to generate the evidence that is presented in those courts of law? I'll just stick to the ICC. We had talked about this over dinner before. The prosecutor, Khan, had announced a 2-year strategic plan to turn the court into a, quote, technological leader. I'm going to remove that grandstanding language that will never happen, and we'll just say the court is now investing money in hiring experts. And the question is the court well suited to hire the right kind of experts and to work in a collaborative setting with other courts, because no court will have the capacity to do this on its own, to create a framework. And so there's a coalition of data protection authorities across international courts now that meets monthly. If you're interested in learning more about their work, I'm the co-chair of the International Law and Technology Interest Group at the American Society of International Law. Last year, we ran an event with the ICC's data protection officer who speaks about that organization. So if you go on the ASIL YouTube site, you'll find that discussion. The short answer, though, is that for these courts, they are miles behind, and so there's a lot of just legitimacy building and trust building to do through taking the right measures towards expertise building and capacity building. So that's where I would first put it, and creating policies that are explicitly outward facing. Around chain of custody, around how you contract out with third parties who are providing the data to you, like civil society organizations, and so on and so forth. But we can talk offline. There's a lot more I can say on that.
I'm Catherine. I'm in 2L. I think what stood out to me from all of you was kind of a lot of these efforts are in like the of these technologies. And I was just remove the, I don't really, know exactly how it works, kind of like the inputs, the bias of racism and ableism and all these things that are going into technology. There's efforts to kind of address it at that point as opposed to once it's already embedded in these systems.
Well, I'll talk about it from a slightly different perspective, which is if you think about neurotechnologies, a lot of the risks of it comes from the data itself, right? And the use of the data and the misuse of the data. So we're already seeing it happening in workplaces, by governments, for interrogation purposes, or aggregating that information to be discriminatory against particular groups. And so then the question is, on device, could you do something differently so that individuals be protected against that data? Could you do edge processing and edge compute of the data? Could you have something like a mental vault, which would keep the data safe for the individual to be able to access and use themselves, but there would be, robust protection measures? The answer is you could, but what are the incentives for the companies to do so, right? And without a robust, set of both liability models, but also incentives that actually shift from traditional and legacy tech company models, which are based on capturing attention and keeping people on device and using their data and commodifying it, it's hard to make those kind of shifts. And part of the reason why I think international human rights law provides a really important kind of way to change the terms of service is exactly what he was talking about, is you start the analysis differently, right? So if it's you have a right to cognitive liberty, then by default, that data stays on device. If you want to have some exception to gain access to it, you would have to prove the limited purpose, right? Like, what's the legality of doing so? What's the purpose and use case for which you can do so? And there'd be a proportionality and a necessity analysis that might occur. So maybe in the workplace, for like limited extraction of biometric data for fatigue levels, it would be permissible. But you'd have to prove that case and then show that you're actually following those data minimization principles in order to align with it. But I don't think you get there just by voluntary agreement with companies to actually design their technologies in ways that mitigate against bias, mitigate against a lot of the harms. Like, hopefully you would. I don't think that most capitalist structures are set up in a way that is designed to align with human flourishing with tech. It's really designed to align with shareholder value, which aren't always in good alignment with one another.
So the question, and Catherine, tell me if I'm not summarizing adequately, but was essentially about efforts to sort of ex ante address some of the problems that we've identified with algorithms. So addressing in the technology itself, for example, algorithmic bias.
Yeah.
And the design of the algorithm. So I don't know if anyone wants to, or the design of the technology. So I don't know if anyone else wants to jump in on that question, having heard it.
Should we take one last question then?
Yeah. One last question. Yeah.
What can people do, especially if they're not going into the legal field or the engineering field, to help bring about positive solutions to these very real problems?
Demand side matters, right? And I think people assume that they're powerless. There are companies that follow different policies and that actually care. And most consumers go right now with convenience over demand side, right? Sufficient demand side would shift things, and sufficient galvanization of demand side for particular, design features and technologies, privacy by design, end-to-end encryption, increased cybersecurity. Likewise, I think consumers, with sufficient demand side would lead to third-party solutions that would create certifications that would help people make decisions between products, right? To say this is a kind of gold standard product because it actually follows the following things that align with consumer demand. But without demand side, it's hard to also have the political will to lead to the changes that need to happen to shift legacy, tech companies and AI companies toward better alignment with human flourishing. So vote with your feet.
One version of that. So when I taught at a summer program at Yale for many years called Young and Global Scholars, and one of the years was 2016. It was the year where everyone was downloading Pokemon Go and playing with it. I'm sure this is your generation. Certainly was not mine. So anyway, all of these students of mine were all downloading and playing Pokemon Go. And at the time, the New York Times were literally showing day after day stories about how this horrible app was collecting data in obtuse ways, and including how child sexual abusers were looking in particular sites for where the children were looking for these gyms or whatever it was called. All to say, you download apps without thinking. And I think that the first thing users need to do is ask the question, what is the benefit to my life? What is the harms to my life? What is the harms to society when I download this app? And that's something that we are nowhere near in educating around.
All right, well, we're at time, so I want to thank very much all of our speakers here and elsewhere. Forward to more discussions.
Great talk. Thank you.
Thank you, speed round. Like, you know, I
Yeah,
can either
yeah.
do my full talk or I'm gonna just
No, I
do a
appreciate what
speed
you.
round.
Yeah, no, I think you did a great job,
Thank
even
you.
for a speed
Thank
run.
you.
That's very well done.
You know, I left out a lot of details, but that's what you do in a speed round.
Yeah, right.
Bye, everyone.
Good seeing you, Rebecca.
Bye. Good to see you too. Enjoy the time together.
Really enjoyed your conference. Really enjoyed